All right, welcome back to Classroom Insider Season 2. This is where we discuss various insider trading cases, and I'm joined yet again by a set of my students. So today I have both Aya and Maya, and I'd love for them to introduce themselves to you. So please say hi and tell us a little bit about yourself.
Yeah, my name is Maya Phillips. I am a 2L at Washington and Lee Law School. I had Professor Woody for torts and absolutely enjoyed the class. And I just realized I had to take more of her classes. And it's just a benefit that insider trading is very interesting. So it's been a great class. And I've been very excited to be able to come on this podcast and talk a little bit about what we've learned.
And
Awesome.
I echo everything that Maya said. I also had Professor Woody for torts during my 1L year, and I'm also a 2L. And I'm already on journal and writing my note, but I had to take another seminar because I want to learn more about insider trading. So it's been a really great experience. I've been liking this semester.
That's so great. I'm so thrilled you guys are here, and I'm so excited we get to talk all things Panuwat, which is one of my favorite topics too. Just jump in. I know you guys did some research and read a little bit about the Panuwat case, but how about we start with just explaining, setting the scene here, and trying to discuss where maybe Panuwat sits. I don't know what is best to start with, either what happened in Panuwat, or if you want to just sort of give us a little background before then, however you want to go.
Perfect. I mean, I can start with just like the basic facts of Panuwat. Panuwat is a former Medivation executive. And so from while he was in his executive position, he learned that Medivation was going to be acquired by Pfizer. And was non-public information at the time that he learned about it. And using this information, he then purchased stock in Insight, believing that when Pfizer acquired Medivation, that Insight stock was going to rise as a result. So it's kind of this like third party that happened to come into the mix. And so Insight is this mid-sized biopharmaceutical company, and they focus on late stage oncology treatments, very similar to what Medivation does. And so within a few days of this public announcement of Medivation's acquisition by Pfizer, Insight's stock rose by 7.7%. And so Panuwat made $120,000 from the stock that he bought. And so then they caught on to this and alleged that this violated the misappropriation adjacent theory of insider trading, as well as also breaching Medivation's theory of insider trading or insider trading and confidentiality agreement, which prevents employees from using confidential information obtained from Medivation to trade in other publicly traded companies for personal benefit.
Yeah,
Okay.
Paddlelock's a really kind of unique and interesting case because it's one of the rare times where you really see the court expand insider trading explicitly kind of into a new area of insider trading. They're calling this kind of shadow trading. And you see a lot of really interesting arguments from the SEC and kind of a lot of jumping through hoops that the court does to be able to hold this case accountable under a less traditional insider trading scheme.
Yeah. Okay. So explain more of that. Let's talk about what is the expansion? What is it the SEC is doing that they maybe haven't done before? Or what do you mean about that being some sort of new area for them?
Yeah, the biggest thing that the SEC did that's really gonna have the biggest impact with this case is that they're redefining kind of what materiality means. A critical point in their SEC's argument was the market connection. So their materiality used to mean that if it's information that would change a reasonable investor's mind in the very company that you're trading in which the information is coming from, then it's material. But here they're saying that information can be material if it's changing kind of the broad market in general. So even though Panuwat is trading in a company where the information is not coming from, the fact that the two companies, as the SEC argues, are in the same market, it is sufficient to fall under an insider trading misappropriation scheme.
Wow. Okay. Based on that, I guess my question for you guys is, where does that leave us? What else? What do we now? Where are we headed now after Panama? Or I guess before we get to that, were there other things you wanted to chat about when the SEC has done this before? Is this the first time?
This happened in 2012 with SEC v. Obis, but this is more with the personal benefit test and how it applied to the misappropriation theory. I mean, there's Strickland was one of the defendants, one of three defendants in SEC v. Obis, and they argued that he breached a duty to his employer, GE Capital, by tipping about a possible acquisition of SunSource to, I guess, one of his friends. And I guess the Second Circuit made like a pretty broad expansion for tip or tippy liability and the personal benefit test by just saying that mere like friendship is enough to satisfy the personal benefit test under the misappropriation theory. And that even though tip or tippy liability and the personal benefit test was developed under Dirks, which is a classical case, the same analysis governed a misappropriation tip or tippy thing. So that's just one example of an expansion of insider trading that happened relatively recently, within a decade, a little more over a decade before this case
Yeah,
came.
and, amazingly, that was just the last episode, podcast of this of
Oh,
this,
wow.
season because I just discussed that with a couple of your colleagues, so we're gonna learn more about that in a second, but in a different episode. But you're right, I think Obis was another sort of high watermark of the SEC moving these theories to different places, and I think you're right. In that case, you saw this weird overlap between classical theory and misappropriation theory, which is sort of here too. Like here it is kind of a mix because you have someone who is in his company and is not trading his own company, but he knows something about only his own company. But he's using that about to sort of to guess. I mean guess would not be the word that the SEC would use, but to sort of predict maybe how other companies would also react to that same information. In some ways it is also this case, I think, is also a bit of a hybrid between classical and misappropriation in the way that Obis was kind of for tipper tippy as well. I don't know. Do you guys agree with that, or do you have other thoughts about this interesting sort of new wrinkle for Panuwat?
Yeah, absolutely. I would agree. You kind of see with these types of cases, and it's kind of been exactly how insider trading law is now, is that it's very messy. And I think it goes kind of to the heart and the overall theme that we've been learning in class is that the victim isn't easily identifiable in an insider trading trade. So therefore, there's a lot of tension between individuals who want to regulate insider trading and individuals who really don't want to regulate it. And kind of as a result between that tension, a lot of insider trading laws expanded through litigation rather than legislation. And so you kind of get a lot of these really messy areas of law where the court tries to find a way to prevent someone from being liable, or in these types of cases where it just feels wrong. This feels like the type of thing the court insider trading is meant to prevent, but it doesn't neatly fall into a certain category. So the court kind of has to jump through hoops, pull in different areas of law to be able to hold these people accountable in these cases.
Yeah, and to
Yeah.
add on to that, I mean, like we learned in our research, this is from a 2006 article in the UCLA Law Review that like there's like 475,000 insider trades every year and like the vast majority of them are ignored by the SEC because the judiciary has adopted like investor confidence and the prevention of fraud as like the preeminent justifications for insider trading regulation. But with that comes a lot of different interpretations of how are we going to apply, like, what is investor confidence or how do we define fraud? So,
Mm.
and I mean, I think we see that also between Texas Gulf and the Ernst and Ernst case as well, like how that those two were just very different applications of are we going to adopt broad implications of investor confidence or are we not?
Yeah, no, that's a really good point. And I mean, I guess when you think about a case like Panuwat, like I take your point, Maya, that it is sort of seems like this maybe doesn't feel fair, it doesn't seem right. But then if you take what you were saying, it is like, what about this would undermine investor confidence? Or, I mean, maybe it would because there are people who are trading based on things that they know that you don't know. But in this case, he didn't know anything about. I mean, I guess that's their point is he did know something about the company he traded in, but he just knew that sort of by application or by like indirectly he knew that. And so that I think is certainly his defense in some ways, which is I didn't actually know anything necessarily about insight. I just know something about my company and I'm able to sort of connect the dots. I mean, you could argue I think that's the reason this is such an interesting case is that you really, I think, can have a pretty robust argument on both sides of how you could see how the SEC thinks this might be an open shut case. You weren't allowed to use information you gained from work to make money elsewhere. That was actually one of his employment agreement policies. He did that and we're done really after that. But you could also see the other side, which is hang on, like, how do you know how do you like make sure you're not running afoul of the law when it seems like it's moving beyond maybe just a few things or some things you could piece together because you could figure some things out. But yeah, I think this is why it's fascinating case.
Absolutely. I say I think it's fascinating because in essence, he's merely just making an inference. So it does feel kind of crazy that you're going to hold someone liable for making an inference, something that anyone can do, something that we really encourage. But if you look at the facts, he made this trade 7 minutes after learning about Medivation's acquisition by Pfizer. So it kind of does bode well to the SEC to be like, but it really wasn't an inference. If he was able to make that trade within 7 minutes, he knew which company he wanted to trade in. Yeah, I
Yeah.
think it's a very interesting case.
And to continue on that, I was thinking of what are the if we change the facts here, let's say Insight was like an IT or like a tech company, not even like in the medical or like biopharmaceutical industry at all. But he just still had a feeling that like this stock was going to go up. Would this have been different? I mean, there's no market connection necessarily. I mean, there's a little bit of it between medicine and tech, but I mean, I don't know. It's very interesting the way the SEC came about this, just coming after.
Oh, it's a good point. I mean, I do think they had a great case for this because it's in this sort of small, mid-sized biopharma, biomedical research companies that probably are. You can see why he knows this will move that maybe fairly small market. But when I was discussing this case with some people before, we talked about how what if you work at NVIDIA or you work at Amazon, somewhere where what everything you know maybe about your company is enough to move other companies well, NVIDIA is a pretty good one because it's a chip maker. And if your chips are down, you don't have the supply, that is going to directly affect a lot of companies that you could figure out pretty quickly. And does that then mean everyone at NVIDIA is prohibited from trading in a pretty wide swath of potential companies because they could have a market connection? Maybe that is the answer, and it's a fine answer maybe to the SEC. But you start to see why this could, in a different set of circumstances, could be a pretty sweeping new prohibition on trading.
Yeah, absolutely.
Yeah.
Yeah, I love this case. I think it's so interesting. Not to be obnoxious, but to put in a plug because another student of mine from 2 years ago and I wrote an article about this exact case. And our argument was that we need to circumvent or sort of carve into any defenses to insider trading by way of the 10b5-1 plan. So these set trading windows, they need to include any peer firms that the SEC would consider as economically linked. Meaning, if I can only trade on certain set days for my company, also included in that plan should be, and if I'm at Medivation, obviously it has to be Insight because if that's my defense, I basically can't ever trade an Insight unless it's in my trading window, or else they might think I'm using inside information because those companies are so closely linked, which is very much an expansion, I think, of what we think about for your employee stock option plans. But the point is, if that's your affirmative defense to an insider trading charge, you need to add into that anything else that the SEC thinks if you're trading here, then you're doing that only from your own inside information. So I think I think this is such an interesting new area of the law here on this one. Yeah, other thoughts? I'm trying to think here what other questions I have for you. Do you guys think this is the right call here? Do you think this is an expansion of the law? And then I guess the follow up to that is, do you agree with that? Is that the best way maybe to handle insider?
Yeah. I was gonna say, I think it's very much an expansion just from reading kind of the arguments the SEC had to make and just kind of seeing the reasoning of the court. They really did have to redefine a lot of things in order to hold Panuwat liable. I think what you mentioned is a very big impact that I think is going to come out of this Panuwat case is that a lot of companies themselves are going to have to revisit their insider trading laws, their confidentiality agreements that they have with their employees to make sure that it covers this types of trading. And then kind of the market connection, I think it's easier in a case like this where the companies are so closely linked, like they both do biopharmaceuticals, they both do oncology. It's very easy to see that market connection. But with cases that aren't as clear and aren't as close, it's going to require a lot of use on experts. And it's just going to kind of be a battle between experts and the SEC. And it's really going to complicate an already very complicated field of law. So I don't think it's providing any clarity, and I think it's really setting the stage for further expansion and kind of, I don't know, not to make a slippery slope argument, but it's going to be very interesting to see actions that were insider trading previously, but now are going to become insider trading.
Definitely.
Yeah, and I think this just seems to be like a new theme of insider trading generally that the court is trying to manifest and expanding of regulation through litigation rather than through legislation. And so it's hard to legislate because of this like tension. I think there's just going to be a lot more litigation, and I think Congress might be taking a back seat after since if they uphold the ruling here.
Yeah, no, definitely. And I mean, as our classes discussed, Congress has kind of taken a back seat since like 1942. Yes, all is kind of made up law through courts up until now in so many ways anyway that this is just sort of the next, I think, instance of that. But yeah, it'll be interesting to see where that goes. Like I said, if you talk to someone at the SEC, they think this is such an open shut case. They think this is
Yeah.
a no brainer. We have a breach of duty. He violated his employment agreement and he used that information to trade. They think this is not even a novel, maybe issue. And maybe that's a fair reading, but there is something that feels a little different about, if you think about this, like from his point of view, like he traded in something about which he actually did. There is some risk. There's some potential of that not being necessarily a one-to-one link of information about his firm and information about another one that, yeah, I don't know. I know we could all talk about it forever because it's really interesting.
I remember I was reading an article researching for this episode, and it talked about a policy concern that Dirks had with kind of the freezing of information that these types of trades is a very significant way that this information comes onto the market, that it becomes public is through watching these individuals trade. So that's kind of the reason why Dirks went the way it did, is that it was afraid of kind of having the reverse effect by regulating insider trading too broadly. It's
Hmm.
gonna cause information itself to be frozen and what comes to the public, therefore kind of putting you right back where you started. And I think that's a concern that I've been reading a lot of individuals in the insider trading kind of law field have with this type of case, is that it could have that Dirk's policy concern and end up freezing the type of information that individuals can obtain through these types of trades.
Yeah, that's a really good point. Yeah, the sort of the function of having certain people trade and moving the values of certain companies to maybe a more appropriate
Yes.
place, maybe. Yeah, that's an interesting thought.
I
No,
think Panuwat also it's like one of these cases that, like, feels wrong,
Mhm.
and they're cases that the court, like, intended to prevent, but they don't fall under the narrow definitions of the scope of insider trading. Then the court's just trying to expand it to then encapsulate this specific instance, like, the Second Circuit, I think, did this in US v. Vlasak when they expanded, like, potential criminal insider trading liability in cases where there was just, like, little to no evidence of personal benefit to a tipper, and but they still I mean, this
right,
held, because they were I mean, it felt wrong. I think that's what's happening here as
right.
well.
Exactly. They just use a different statute in that case because 10b-5 was too hard to prove because of all these things. Like 10b-5 has all been sort of now created through the courts to be this extensive regulatory scheme where you have to get a lot of elements you have to show in order if you're the SEC. And so then, yeah, and you're right. I think the Blackjack case was one that showed, hold on, there could be maybe a shortcut to that if we just use something like the mail and wire fraud. And so I think we'll see a lot of that still, especially if some of these cases are tricky to pin down on the facts. But in that case, it's criminal because that would just be the DOJ bringing that type of case. But yeah, I think so. Panuwat, and so maybe there's something to be said there that this is the SEC, this isn't the DOJ and Panuwat. So there might, in theory, this is a little dialed down because it's civil, not criminal. But yeah, I mean, we'll see what the outcome ends up being. Actually, where it is, I assume he's appealed this. I know he filed a number of appeals about just motions practice stuff, but then I assume where are we in Panuwat? Do we know?
I know it was recently upheld, and I believe he's appealed again, so we'll see if that appeal gets taken up or anything.
Yeah,
Yeah.
interesting.
And I think it's interesting that the court is also bringing in the reasonable investor. Like, what is the reasonable investor here about, like, information that Panuwat knew? Would a reasonable investor have known that? Or is this, like, it's just an expert investor that, like, really understands the market well, and how do you define like a reasonable investor or an unexperienced investor or like an expert investor? I feel like it's very just fact driven at that point.
Yeah, that's a good thought that he maybe could say I could have gotten to this place just by being like studying this industry enough without maybe using the inside information I knew. I don't, yeah, or Yeah, maybe I don't know if that's where you're going with that thought, but that would be
Yes, yes.
interesting type of defense. I mean, he doesn't really have that defense, unfortunately, because he was sitting in the room and he knew all that stuff. But yeah, and that actually was some of the reasoning behind 10b5-1 plans, where their SEC was like, listen, you're gonna always have inside information in your own company. So let's just set up like a preset time because otherwise we'd be fighting every time when you traded about what was the reason you traded. So just let's just set it out and not worry about it and not have to question your intention or motive or your timing because it's just preset. So that was a thought about why we have now these types of employee stock options windows, but anyway, or stock trading windows. Anyway, yeah, there's a lot always to unpack about Panuwat. So, do you guys have any sort of final thoughts or crystal ball ideas of where we're gonna go post Panuwat world, or sort of any final thoughts?
So I am writing my paper for the class on kind of the Stock Act and how do we hold congressional members responsible. So I think that with the court's willingness to kind of create a new area of insider trading to encapsulate these types of trades and these types of individuals, I think Congress should be very afraid that the court might create a new area to encapsulate them. So I think that's a very interesting place where insider trading could head next.
Yeah. Okay. Good point.
Yeah, I think I mean, we've been following Dirks for a long time, and Dirks is still present here, and Justice Powell's jurisprudence is still here. Even though it's a classical case, it's still I mean, it's a problem in Dirks. One of the policy concerns in Dirks is that the SEC overreach would chill diligence by investment advisors and those with unique knowledge, of a company's value, and so I think this, like, overreach of Panama could chill, like, discovery by purging anyone working in the industry from trading in that industry.
Wow. Yeah, that's a good point. This is great. I have learned so much from you guys. I've had such a blast chatting with you, and I'm so appreciative that you did all this work and research and could have a really, I think, fun and interesting conversation about this. So if you don't have any final thoughts, we can sign off here. And I thank you guys for being on.
Yeah, thank you for having
Thank you
us.
so much, Professor.
All right, awesome. See you next week.
Alright, see you.
Bye.